we'll start with page 1. We'll move to page 2. Page 3. Page 4. Page 5. Page 6. Page 7. Page 8. And then the last page is page 9. I did have a correction, but I'm trying to find my document in which I highlighted it. Getting back to page 3, just a slight correction there. In the second paragraph, the very first sentence, where it says Member Hamilton referenced subclause 18.1, which he noted is a responsibility that should only be carried out by the board, and suggested that the relevant provisions would just include a B, need to be reviewed. All right, that was the correction that I saw in the minutes. And so I will ask for confirmation of the minutes. So moved by Member Gale, second.
I'll second it, Chair.
I second it.
All right, seconded by Member Dana Dixon, Senator, Member Dana Dixon. Are there any matters arising from the minutes? If none, we will move on to matters for discussion, continuation of the clause-by-clause review, and we're looking at new clauses, 23, 34, 35, 36, 37, and 38.1. And we'll also be looking at the proposed disqualifying offenses, a much shorter list than the one we had before, but I do have questions when we get there. And so I'll call on our technical professionals for the continuation of the clause-by-clause review.
Good afternoon, Chair and members of the committee, colleagues, all. In relation to clause 23, Chair, as noted on the document, that clause was treated with at the last meeting in relation to subclauses 5 and 6. It is noted as 24, 5, and 6, but based on the drafters redrafting, the numbering has been changed. But it was treated with and agreed by the committee at the last meeting. So with your permission, can I move on to clause 34?
Please go ahead.
The clause 34 was amended as a result of the decision to have the police record, the criminal record check of a teacher at the initial stage of registration. And so as a result, 34(2)(b) has been amended. I'll read from 34(1). Application for registration as a teacher. 34(1). Subject to this act, every person who, on or after the appointed day, teaches or proposes to teach in a school or other educational setting to which this act applies, shall apply in the prescribed form and manner to the council to be registered to do so. 2, an application under subsection 1 shall be accompanied by A, the documents or information on which the person relies to establish that the person meets the eligibility requirements specified in section 26. B, the written results of a criminal record check. C, any other document or other information reasonably required by the council to decide the application. And D, any prescribed document or other information.
Council. So you're putting this to the committee? Okay. Members, clause 34 revised, clause 34.
Chair,
Yes, please go ahead.
with your permission, is there a time limit on the police record? Must not be older than 1 year or anything like that that is being proposed or required?
Member Brown, could you repeat the question?
Yes, Chair. My question was whether or not the requirement for a police record to be submitted, an application for the job, whether the police record ought to have a minimum age, like say not older than 6 months or not older than 12 months, whether or not there is a age limit on the record that may be police record that may be submitted.
Council, could you just repeat the decision that was taken on that?
So a police record lasts for a particular period. So the submission of that check, it must be valid for it to be accepted. So that's the main thing for the submission. It must be a valid police record that is submitted.
Chair, what I gather Senator Brown might be asking is a determination. Yes, the police record would have a defined period attached to it. Senator Brown, you can clarify for me if what you're asking, if someone has in their possession already, for whatever the reason, it might not be associated with this application to teach, but you would have had in your possession a police record, and you would have had it for 6 months. If that police record would be one that would be eligible for you to put forward in this case. Is that what you're asking?
Essentially, somebody applies for a job in November, but the police record expires in December. Is that sufficiently current? So if the word current police record is used, that's fine with me. I'm just trying to make sure that we don't get into a situation where by the time a decision is to be made, the police record has expired.
Chairman, just looking at this, it doesn't exactly mention specifically police record. Am I right? Criminal record. Right. Criminal record check. But I don't know if we could specify anything or should specify anything further. The council will indicate what's the timeline. They may even say it can be provided every 2 years. I don't think we should go further to say that it must, what time period it should have. It's normally a year and it expires or something. I don't know that we should, maybe I'm not following what Senator Brown is trying to deal with, but if I'm understanding him, then I don't know that it should be dealt with specifically in the Act. I think we should give the flexibility to the council. But maybe I'm missing the point.
Council, I recall I know it's been a while since we've been here, given the Christmas and so on, but I recall that we agreed that police records check would be required for persons entering the teaching profession upon registration and for persons already in the system upon application of an authorization to teach or a license to teach. And thereafter, given that they would be under the JTC Act, that any infraction would be caught, because the police record only goes for any infraction. Any infraction would be dealt with under the Act. Because it wasn't making sense for us to require a new police record upon a renewal. It was not making sense, yeah.
Chair, you are quite right. The last discussions or deliberations that we had, we spoke about the concern of this constant renewal. And once you are required to enter the system with a record check as defined under the legislation, there would be no need for you to be going through this constant renewal. I even recall that at the beginning we were saying every year, or it went to every 2 years, and then there was a suggestion made, and you alluded to it, that if there was an infraction, then that would normally form a record of some sort. And then under the offenses that constitutes the disqualifying offenses would treat with that. We were trying to safeguard this repetitive action of going for renewals and renewals and renewals. It's just for you to enter the profession demonstrating that you would have qualified with a clean sheet, and then you expect and understand that teachers would stand up to the scrutiny and standard to which the legislation is, the provisions of the legislation is calling for. I believe that that was where we had left those discussions last year.
With respect, this clause is about new applicants. And if I may put it another way, if somebody has a passport, for example, and the passport expires in 6 months' time, that may be a bar to travel to some places. So I'm not going to press this, but I repeat my example for Senator Bryan. If somebody applies in November, but the police record expires in December, which means they'll have had the police record for probably 11 months. Is that current enough? And we're talking now first-time applicants after the legislation has come into effect. So I'm not going to press it, I'm just simply asking, is it our desire to put a current record or just any record, one expiring in a month's time? That's fine with me if that's the position, but I'm just querying because it may become an issue later on.
I think that now that I fully understand Senator Brown, I still maintain the position that it should remain and leave it to the regulator to determine whether it should be at least 6 months old or 1 month is sufficient, or it should be 12 months old. I don't think that we should legislate down to that detail.
All right, so agreed, members? Because there will be regulations developed out of this. Yes. All right, the committee members so agree. Please carry on, Council.
Sorry, is that an agreement for regulations to be made relative to that point? Or is it just an agreement? I don't have one or another school with me, but I would just suggest that if they access a police record, a criminal record, then I can't see regulation overriding the principal legislation. But it's neither here nor there with me right now.
But I thought you were inquiring about how much time is left on the police record, whether it's a month or whether the council is going to be requiring you to have a very current one. And what we are agreeing is that we would leave that up to the council in terms of whether they require it to have been gotten yesterday versus 6 months ago. Right, Member Braham? Yeah.
Well, just to say that if they access a criminal record and that has been presented, that has to be accepted by the council. Council can't override the act. But as I say, let's move on. There's another time and place for more of this.
Council?
Thank you. Clause 35. This was, I'm not sure if members have the old provision at hand. However, this clause was amended to remove the wording at subclause 2B, 1 and 2, and C, and as a result, the renumbering is now from A to D. So it was A to E, and it's now based on the amendment. It has now been reduced. So I will read as is. Application for license. 35.1, subject to this act, every person who practices as a teacher or proposes to practice as a teacher shall apply in the prescribed form and manner to the council for a license to do so. 2, an application under subsection 1 shall be accompanied by each of the following. A, the documents on which the person relies to establish that the person meets the eligibility requirements specified in section 27. B, the written results of a criminal record check. C, the prescribed application fee. And D, any other document or information reasonably required by the council to decide the application. So the change was made as a result of the need for the criminal record check at the initial application. Prior to that, the requirement was for a consent to be signed by the applicant. And so those provisions were removed.
All right, members, I put to you the amendment in clause 35. Or B, 35B, council? Because I see
Yes, Chair.
27, okay. 35B. I put to members amendment in 35, clause 35B. Aye, so moved. So accepted. All right, council?
36 was a similar change, so I'll read as now stated. Application for authorization to teach, 36.1. Subject to this act, every person who is not a registered teacher or a licensed teacher who teaches or proposes to be an instructor in a school or other educational setting to which this act applies shall apply in the prescribed form and manner to the council for an authorization to teach. 2. An application under subsection 1 shall be accompanied by each of the following. A. The documents or information on which the person relies to establish that the person meets the eligibility requirements were specified in section 28. B. The written results of a criminal record check. C. The prescribed application fee. And D. Any other documents or information reasonably required by the council to decide the application.
I put clause 36B as amended to the committee members. All right, so accepted. We'll move on to clause 37.
Supporting documents for application. 37.1. An application under this part shall not be considered unless the prescribed documents and information and the prescribed application fee and any other amounts payable to the council are submitted by the applicant. 2. An applicant shall disclose to the council, by way of the voluntary declaration required under subsection 3, the particulars of any prior convictions. 3. The information contained in or accompanying an application shall, if required by the council, be verified by a voluntary declaration.
Okay, go ahead, member.
And to council, Minister, so you ought to state if you have prior convictions. But what happened if at the time that you apply, you are charged with an offense? Should you state that as well? Sometimes people are charged for a long time, it meaning that the system takes its time to conclude a matter. And I'm charged with something that may be of relevance. The council may wish to take that into account.
Chair, based on the scheme of things where we have been ensuring that we treat with charges and conviction, I think it's a good point that member has raised. So it would be for the committee to determine whether we'll go with senators or members' proposal or point raised, rather.
So member, do you want to just go through that again so I can put it to the committee in terms of just stating where this would be, and yes.
That's an applicant, chairman. In addition to setting out what is set out at section 36, clause 36.1 and 213, you'll have them indicating whether at the time of application they are charged with any offense, and to, if yes, to give particulars thereof.
So members, I put that to you, that an applicant at the time of application should indicate if they have been charged with any charges and to say what that is.
May I suggest, Chair,
Okay.
that ought properly to go in the prescribed form on which the applicant is making the application for the job. And so, just like in a visa situation, have you ever been charged? Could be one of the questions posed in that form that need to be answered rather than being placed in the legislation itself. I think that's where it properly belongs, in the prescribed form.
Member Brown?
Technically, then all of them could be in the prescribed form. Are you convicted? It could be in the prescribed form. But the problem I have is that if some of them are statutorily required, why treat the charge, whether you're currently charged with any offense, differently? That's the only thing that bothers me. Because if you treat one differently, a court or the reader might think it is less important. I just, maybe counsel could advise, but that's the thought process I have.
Council, is there anything you'd like to add to this before I put it to the members that at the time of application, the applicant should declare any charges, put it in the act, as well as I'm sure the council will ensure that it's on the declaration form.
Sure, it is a part of the declaration, the voluntary declaration that that the person is required to give under subclause 3. So it's included in that voluntary declaration. So 3 says the information contained in or accompanying an application shall, if required by the council, be verified by a voluntary declaration.
Just to be clear, the voluntary declaration is part of that prescribed format. In other words, if you voluntarily declare this information, there is somewhere that it is recorded. Not in a verbal format. It's written, documented.
If you don't require it, because you see 3 says the information contained or accompanying an application shall, if required by the council, be verified by voluntary declaration. So I don't expect that all application and everything would have to be verified by voluntary declaration. It is an additional requirement if they so choose. And that can be anything, but it would not cover, as presently set out, issues dealing with charges. So I think the charges should be put in specially up at the top somewhere, and then the voluntary declaration, if they want it, they can also ask for it.
Just to clarify, Chair, would that mean, Senator, that somebody could be denied employment because they are charged? and not yet convicted? And may I just also inquire from the council, how long the process between application and approval is likely to take?
The idea is for the council to take these matters into account. There's nothing that says that if you are charged with a minor motor vehicle accident, you can indicate what type of thing, if you want to say serious, on any serious offense or whatever, that the council will take that into account. Well, let us say you are charged with a sexual offense. The council may wish to inquire then in the circumstances and wonder whether it would be safe for me to be admitted to teaching before the matter is resolved. So this situation happens almost every day, you know. And sometimes the person who is charged is actually guilty. Sometimes. So I think it's information that they should have, and then they have the discretion as to how to treat with the information.
Could I suggest charge for a qualifying offense, a disqualifying offense, rather than charge generally? That may get my support.
Chair, how I read this particular clause is for the provision of information. For you to, in the documentations that you are submitting, you are required to provide the information inclusive of a voluntary declaration. That's it. What Senator Braham would have suggested is that consequential to you providing the information, then later on the council will determine a particular action, not in this particular clause. This clause is speaking about the requirement to provide the information. Now, if it's information that you would have provided that would have been associated with the offenses which constitutes a disqualifying offense, then elsewhere that would be treated. But not for this clause, nobody can use this clause in the first instance because you provide the information. You're going to be disqualified.
Chair, I'm just looking at the scheme of the bill overall. Currently, if a person is charged with an offense, recall the previous discussion or the discussion last year where that gap was in the bill where only if a person is charged with a disqualifying offense, that's when the license is suspended. We have changed that to say if they are charged with an offense, their license will be suspended. That was the discussion I recall because it was also alluded that that is the current gap in the system, that once a teacher is charged with an offense, there's no provision under the education regulations to, I don't want to say interdict, but to suspend the person pending the matter being treated with. And so that was the gap identified at the last meeting, and if my memory is well enough, as I think it is, the decision was to say charge with an offense and not just a disqualifying offense. And on that basis, if it is that a teacher's license will be suspended upon being charged, I don't see where we can grant a license to a person who is charged with an offense, because unless it is going to be granted and then suspended, because a person who is with a license, once they are charged, will be suspended. So based on this scheme of things, I don't see where we could grant a license to a person who is currently charged with an offense. That is what I see based on the scheme of the bill.
Anything further, Member Graham?
Brought to reminded us of, confirmed that the person, the applicant, ought to declare any charges. Now, I think we should just declare the charges. The council then in its discretion can determine that this is a traffic offense. For speeding, is neither here nor there. Or the council may say that this is an offense that affects young people. Therefore, you need to give us more particulars. What is the circumstance of the charge? And they will then decide, boy, we better be safe and wait until the case finish. Or they may decide, well, the circumstances, it is 10 years that is going on now, maybe we should proceed. I think that flexibility should be given.
Chair, am I correct that council, not King's Council, but council doing the drafting is saying to us that once you're charged, you can't then get a job in the system? Once that charge remains, subsists, you can't get a job in the system because if you're in the system, you'll be suspended. Am I correct? That's what is being said here?
I don't believe so. He's saying that if you're charged, you can't get a job in the system, but that's not what I hear you saying. It depends on the charge, right? It depends on the charge.
I am saying that it gives the council, it is not saying necessarily that you're not going to get into the system, but they can take that into account. They have to take a number of factors into account in determining whether you get your license or whatever it is. And one of those factors could be that some young person has accused me of a serious offense against young people, children or young people. And in those circumstances, it may be safer not to allow me in just yet. Clear your name. There are other times when the circumstances suggest that they can proceed. I'm not prescribing it because it's very difficult to prescribe. I wouldn't say that if you are charged, you should not be admitted. But it should be a matter that they know. And indeed, there are other, I know the lawyers require you to declare if you are charged. Initially, they did not, until they discovered that people were being admitted who were under serious charges. And then somebody said, but we didn't know that. And then somebody else says, but your form didn't ask them to state it. So it is actually a true and practical experience. And in those circumstances, I have seen where the council have decided that a person who was charged is permitted in because the matter is at an end, maybe withdrawn.
Are the extent of the charge?
The charge is frivolous, in terms are minor, but at least to make an inquiry.
With respect here, I understand my colleague's position, but the position of council in explaining earlier that the scheme of legislation is that if a teacher is charged, that teacher is suspended. She didn't want to say interdicted, suspended. So if that is the case of an existing teacher, I understood her to be saying, then a teacher applying for the job would also have to be excluded or granted and then suspended. Granted the job and then suspended. So I want to be clear if that is the scheme of the legislation now, because clearly Senator Ransford does not agree with that either. from what he's saying, depending on the magnitude of the offense. So, can we be clear as to what is the scheme of the legislation now? And I understood it to be that if you're in and charged, you are going to be suspended. So if you are charged, you can't come in. Just want to be clear if I heard right.
So members, what I am understanding is that you will be required, as an applicant, you will be required to declare any charges. It is up to the council to look at the details of those charges and decide if that applicant decided on the magnitude of the charges, using the example of Member Braham. If it's a traffic ticket, you are driving 5 miles over the speed limit, it may not be considered to be something that would exclude you from the profession. But obviously, if you've been charged with being a sexual predator, that would be a serious consideration for you as an applicant. So that is my understanding of this clause. Counsel? So I'm putting clause 37.
Chair,
Right.
before you put the clause, I didn't hear from counsel. I don't know if she spoke, but she had made some comments earlier, and I'm wondering if I heard correctly that if a teacher is charged now, that teacher, not now, but when the bill come in, would be suspended. And my understanding doesn't say charge for a disqualifying offense, but charge generally. And I just wanted to, if she could repeat what she had said earlier about a teacher being charged, because it's important that we move beyond silence. So be clear on what the scheme of legislation is saying in respect to charge.
In relation to the teacher who is currently in the system, if that person is charged with an offense, then the license or authorization to teach will be suspended. Or it says may be suspended. That's what the provision states. In relation to a person entering the system, I think the discussion was to see whether or not, based on the charge, if it is that the person must not be granted a license. It's not like it's not currently in the bill, and so it would be a matter for a decision as to whether that has to be specifically stated in the bill.
Oh, I'm sorry. Council's position is that if a current licensee under the Act, when it becomes an Act, is charged, the council may suspend them. So, depending on what it is, not that they must be suspended. So that if Again, using my example, a trivial type of offense, speeding or using your phone while driving, that council may not waste their time with. But an offense against a minor or a young person may be a different thing. An assault on the principal may be a different thing. So they exercise their discretion. And I think that even without the bill, they would have had that discretion probably. Certainly the employer would have that discretion. But the bill, I think, is properly give them the discretion. The second part of it ties in well with the discretion. If I have a discretion to suspend, to charge, then I should have a discretion to consider whether I should accept you on basis of charges. I think that's what I understand her to be saying with great confidence.
Yes, 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 committee. Yes, chair. I mean, member, sorry.
All right, I put again to the members the amendments in clause 37. Clause, let's see, 1, 2, 3.
Does the amendment take into account Senator Graham's point about discretion and the maybe versus the shall?
Right, so it currently says, if you're a current teacher, council, read if you're a current. Could you read again for us, please? 37, clause 37 with the amendments.
37.1, an application under this part shall not be considered unless the prescribed documents and information and the prescribed application fee and any other amounts payable to the council are submitted by the applicant. 2, an applicant shall disclose to the council by way of the voluntary declaration required under subsection 3 the particulars of any prior convictions. 3, the information contained in or accompanying an application shall, if required by the council, be verified by a voluntary declaration.
Does that capture what we've been discussing? It doesn't.
You want to
So you have to now get a new formulation.
I just wanted to ask. It's entirely out of what the discussion is about, but in relation to the clause, this any other amount payable to the council. Is that defined? No. This any other amount paid by the council. Because when you put, this could have been interpreted that the council can just determine at any point in time what other amounts could be paid.
Yes, what's wrong with that?
So we're leaving it at that then. Any other amounts to be that you're going to owe the council get up tomorrow morning and say,
They're made up of reasonable people. Teachers are reasonable.
Teachers might can't afford it, but anyhow.
Two, an applicant shall disclose to the council by way of the voluntary declaration required under subsection 3 the particulars of A, any prior convictions, and B, any charge for a criminal offense or offense. I'm not sure which is preferable. Should we state criminal offense or just offense? Should I reread? An applicant shall disclose to the council by way of the voluntary declaration required under subsection 3 the particulars of A, any prior convictions, and B, any charge for an offense.
All right. I put to SG. Please go ahead.
Sorry, good afternoon. That was an error. I don't have anything to contribute.
All right. I put the amended clause 37 to the committee to include declaration of any charge for any offense. So moved by committee members.
I beg to disagree. Just want to state my disagreement for the record. Somebody charged with 3 ounces of ganja ought not to be required to report all of that. It ought to be a disqualifying offense relative to the charges. But as I say, I disagree with it as it is. But leave it for the majority to decide on. I wish my position to be registered as disagreeing.
So noted, member. Clause 38, council.
It is interesting. It says, before using the information obtained from a criminal record check to determine whether an applicant is a fit and proper person to teach, the council shall A, disclose any negative information to the applicant and allow the applicant a reasonable opportunity to make representation. So what I'm trying to follow now, the negative information, is it the intention, any negative information arising from a criminal record check? Is that it? Is that what this is covering? But who is the criminal record check? How is that done? Isn't that the applicant would go and get it and take it to the council? Is that what you have in mind here or you have in mind if they have any negative information from any other source? I don't understand. It seems to be suggesting negative information from the criminal records check, which the applicant would be well aware of it, because they would have gone down and stand up in the sun and Duke Street to collect it. So that's why I wonder.
Member, I think it was drafted this way because the previous clauses spoke of giving a consent for a criminal record check to be done.
Sufficing to say as well, Madam Chair, that they don't have to stand in the sun anymore.
I pass there and I don't see them in the sun anymore. So that is true.
As long as let it pass too early in the morning before the sun is out.
No, man, that time they will be standing there, my member Brown, because it's not open as yet.
All right, with that, there are no amendments here to 38 then, are there? Okay.
If the clause
Or
stands
the
as it is,
council is conferring.
sorry, I'm sorry.
You want to respond before I? All right.
So the proposed redrafted provision is before using the information obtained from a criminal record check to determine whether an applicant is a fit and proper person to teach, the council shall allow the applicant a reasonable opportunity to make representations to the council about any negative information obtained from the criminal record check. Before using the information obtained from a criminal record check to determine whether an applicant is a fit and the proper person to teach, the council shall allow the applicant a reasonable opportunity to make representations to the council about any negative information obtained from the criminal record check.
Suggest, now drafted by when you just spoke, suggest that the council may be taking into account the information from the criminal records check only. That when they are taking things into account, that may be a factor. So you'd have to say something like before they take it into account. You follow what I'm saying? I don't know if I'm making any sense. They can take, that's a factor that they will take into account. But they may have other information that they may decide to use. No? No? Go ahead.
The renewed clause is speaking specifically in my mind to what would have been obtained from the criminal record check. And so it is giving the applicant an opportunity to represent themselves against what would have been obtained from the criminal record check. It is not saying, because A has been taken out, and the fact that you no longer have to disclose any negative information, meaning that if your neighbor, member Braham, had suggested something to the council that you did something wrong, that can be taken into consideration. This is no, the taking out of A is saying that nothing else can come in that was never part of the record check. You're speaking specifically to what would have been disclosed by the information obtained under the criminal record check. And so, as a result of that, if there was any negativity associated to that, you're saying to the applicant, I am giving you the opportunity to represent this issue. And it might be the same traffic thing that you spoke about, or some of those issues that we had rejected in the previous schedule for disqualifying offenses. So it's doing two things: dealing with the negativity that is obtained from the criminal record check by the applicant and giving the applicant an opportunity to answer to them and represent themselves. Give me a reason why, having made the declaration. But I like the removal of A, because A can be bad mind.
No, I don't. You cannot limit the information. I can understand if you say that the council is going to take into account something negative, you should disclose it, regardless of where the negative comes from. But to say that you should only get negative information from the criminal records check is short-sighted, because that's not the only way. Well, maybe it shouldn't be taken out. Suppose I write and put in an affidavit information to the council that is of value and importance, and I'm willing to go on record, and the council considered credible, but it was not the subject of a criminal charge, so it is not a part of a criminal's records check. The council should then ignore it? Is that what you're saying?
But remember, it would have to be that in the first sentence you include from any other sources, right? Before using information obtained from a criminal record check or other sources to determine whether an applicant is fit and proper to teach, the council shall, and I can see how disclose any negative information would remain. But if you just use the criminal records that the person went to get, there's nothing for you to disclose to them, right? I think you're talking about information from other sources.
Council makes the point, though, that there is a possibility that the council may seek the consent of the applicant to do their own criminal records check. I don't know where that they will do it, but theoretically it's possible. And I suppose the applicant would not have had knowledge of it, and council should not simply quietly take it into account. And I think that's what it is covering. But if you leave it like that, it appears to be suggesting that negative material that may be considered will be limited to the criminal records check, and that would be very short-sighted.
So that's what I'm saying. We should be included. Yeah, okay.
May I enter into the conversation?
Go ahead, member.
Yeah. I share the view that criminal record will be limited, and I share your suggestion, Minister, for whatever sources it may come, because that would also include charges. And I believe the principle of natural justice is that if an adverse decision is to be taken against someone, they should at least be given an opportunity to respond to it. So I can support that clause if it's broader than a criminal record.
Chair, just to point out that this specific provision is speaking to the information from the criminal record check. So therefore, if it is that consideration should be added for any other negative information received by the council, then we would have to amend the provision to to widen that. Because as it is now, the provision only treats with the criminal record check, as the marginal note dictates. So we would need that
Right, so
information.
I put it to committee members for clause 38 for us to widen it from just saying information obtained from a criminal record to include in any other sources, and that this should be disclosed to the applicant and allow the applicant a reasonable opportunity to make representation to the council. So members, council is requiring some time to look at clause 38 with a widened remit.
The proposed clause 38 reads, before using the information obtained from A, a criminal record check, B, a charge for an offense referred to in section 37, or C, any other source to determine whether an applicant is a fit and proper person to teach, the council shall allow the applicant a reasonable opportunity to make representations to the council about such information. I'm going to have to put negative.
Please read it again.
Before using the information obtained from A, a criminal record check, B, a charge for an offense referred to in section 37, or C, any other source to determine whether an applicant is a fit and proper person to teach, the council shall allow the applicant a reasonable opportunity to make representations to the council about such information.
Too wide. Before using any information, I think you have to say any negative information. I don't know. I don't know what the members think. Or maybe it's fine.
All right, so we were discussing the whether to use the word negative and the matter of allowing the person a reasonable opportunity to make representation. We're saying that if it was positive, you would not need the person to make representation. And a charge would be looked at as negative, or whatever information on the criminal record check would be looked at as negative.
No, that response covers it. It appeared wide until you clarified it. Because in the first instance, it gave the impression that anything you could have responded to. But you're right. If it's positive, there is no need to speak to it. The point I like is that it gives the opportunity for the applicant to respond and to clarify and to even represent themselves. So I can say aye.
All right, I put the revised clause 38 to members. So moved? Aye. Yeah, okay.
Aye.
Aye.
Do we move now to disqualifying offenses?
Chair, the marginal note will be changed to read consideration of negative information on applicant. Chair, there is also the matter, we looked in the minutes and we did not see where confirmation was made in relation to clause 57 regarding the suspension of the license or an authorization to teach where the person has been charged. It's currently stated as charged with a disqualifying offense. So we did not see a confirmation to change from a disqualifying offense to an offense.
Could you just reread 57?
Fifty-eight.
58.
58.1, where a registered teacher, a licensed teacher, or an instructor has been charged with a disqualifying offense, the Professional Practice and Conduct Committee may suspend the registration, license, or authorization to teach, as the case may be, held by the person. Where it is proved to the Professional Practice and Conduct Committee by a certificate of conviction from the Registrar of the Supreme Court or the Clerk of the Parish Court or from an equivalent officer from a court of competent jurisdiction outside of Jamaica, that a registered teacher, a licensed teacher, or an instructor has been convicted of a disqualifying offense, the Professional Practice Practice and Conduct Committee shall, as soon as possible and without further inquiry, revoke the registration, license, or authorization to teach, as the case may be, held by the person. So the contemplation is really in relation to 58.1, where it only states disqualifying offense. So the discussion, Chair, was to change it to offense based on the current gap in the system. But it's discretionary. It was discussed before as well, but yes, it was discussed again today.
Council
It's
59.
58.
is the
Suspension or revocation of registration, license, or authorization to teach. I think the document that you have, Chair, would be saying 59. That I read from the drafter's draft. That would have been updated with the numbers. So it's 59 on the document based on what Mr. Nash just showed.
All right. You require another reading? Okay.
We would know in treating with the gap. We originally, we were speaking about disqualifying offenses that were cleared. Once we can sort out the gamut of those disqualifying offenses. But then we would have moved to the question of charge, and charge is in relation to offenses. But I just wanted to be satisfied that in speaking of an offense and for the council to take a position, it ought to be a discretionary in nature. And so the use of the term may would qualify that. And does it give the opportunity for the individual to represent themselves also?
Based on the scheme of the bill, that the provision that is further up in the bill will take care of that.
We'll take care of that. Okay. Because I always want to give the individuals to be able to respond to any claim associated with a charge, right? In their applications. All right.
And I mean the principles of natural justice.
Huh?
The principles of natural justice.
In relation to the principles of natural justice.
Yeah.
So, Council, you're seeking confirmation that
To remove the word disqualifying offense in 59.1 on the October 3, 2023 document to read charged with an offense and not charged with a disqualifying offense.
All right. I put that to the members. All right. Thank you, members. Do we move now to the schedule offenses which constitute disqualifying offenses? All right. Members, do you have your printout? Well, the heavier version just explained the disqualifying offenses. All right, please carry on, Council. All right, members? Yes.
Where we were coming from was an expansive list of offenses, some major offenses and some minor in nature. And we had raised some concerns around exposing an applicant or someone practicing in the profession to be disqualified for certain offenses that would have been minor in nature. Under the offense at common law, challenge to fight, for example, or public, what could have been constituted as public nuisance. Those were some examples, and we had said to the team, go back and review and stick to those that would have been egregious in nature or major offenses. And I think in my mind, they would have come up with a reduced list, but specific to those that are egregious in nature. And in my mind, I am satisfied with the list that have been compiled and presented today. I haven't gone through them thoroughly, but I'm looking at those associated legislations that would have been represented and in support of what would constitute disqualifying offenses.
Except member, in item 4, I note that in the revised list that we have, I see sections 16, 17, 18, 21B, well, was removed. And if you look at under 4, number 4, any offense of the dangerous drug, right? And if you look at the original FAT document relative to this revised one, in this revised document, things like removal of dangerous drugs from conveyance, etc., without a license, that's taken out. Tampering with dangerous drugs in transit, that was taken out. Yes, causing or procuring any dangerous drugs brought into the island to be diverted to a different destination, that was taken out. Using the postal services for drugs, that was taken out.
Here, because you still have the categories to which, you know, the legislation that has been listed, and what they have sought to do is to exclude some. But maybe, as Member Braham was indicating quietly, just use the particular, just refer to the particular legislation, and the particular legislation would cover it, rather than be specific. Maybe they have missed out why it has been excluded, but I don't see why it should have been excluded.
Council, the list, we have a list of offenses under the various legislation. What would have been sort of the criteria that caused you to choose one as against the other? Because I was wondering if you could just simply say offenses under the Drugs Whatever Act, offenses under the Sexual Offences Act. Is it that we have to list? I would imagine. So maybe if I understand the basis why you list some and leave others. Oh, they suggested it. Oh, I see. Okay.
Well, I know, member, at one of our meetings, just because of the voluminous nature of the document we got, which, if you look at it, it was just explaining. A lot of the pages were just explaining, but I think that was missed by members. It wasn't really as voluminous as they thought, and so they asked for our technical staff to go through and maybe pull out the more egregious ones. And that's why we're here. But as I'm comparing this one, this new revised one, and looking at the prior one, I'm seeing many things taken out that I think should still be. Right, because even offenses under the Forgery Act, that was taken out.
Remind me why it was not permissible to just simply refer to any offense under the Criminal Justice Suppressions of Criminal Organizations Act and leave it like that. Why was it thought necessary? Did they give an explanation?
So recall that there's a definition for disqualifying offense, which is a term of 2 years, 2 years or more imprisonment. And so when the Legal Reform Department was compiling the list, they zoomed in on those offenses that would be 2 years and over for the committee to appreciate what would, based on the definition, what would constitute a disqualifying offense.
Or please go ahead, Ms. Spence.
Yes, that's correct. I'm just indicating that what Mrs. Gordon-Jones has said is in fact correct. We prepared the list based on the definition of disqualifying offenses, and we wanted the committee to appreciate what offenses would constitute disqualifying offenses.
So there is a definition of disqualifying offenses, which is 2 years, etc., etc. So if you had that definition and then you go on to say offenses under these acts without listing them, but nevertheless complying with the definition, I mean, this is an inelegant way of putting it. You would then avoid all of the listing, and everybody knows that you would only be dealing with those that are 2 years and more. And then you wouldn't leave out any, if any, and so on. I don't know. Would that be a convenient way, or that's not regarded as proper drafting?
SG, please go ahead.
Thank you, Chair. Good afternoon again. I just heard Senator Braham make a proposal, but that's actually what's in the bill now, the 2-year period. But it was, I don't want to say it wasn't accepted, because I think the committee, I'm not sure if there really is a decision yet, but the committee was looking in another direction. But the whole thing about, if you look at the definition section for disqualifying offense, it says an offense for which a penalty is a term of imprisonment of 2 years or more, which is something that we have in other legislation, but it wasn't And many committee members wanted a different approach. Thank you.
So, Solicitor, may I ask you, if we have the definition of 2 years, would we then need to be listing them as well?
No, but the committee wasn't agreeing to the 2-year definition. It wasn't agreeing to what is defined. No, what they wanted was a list instead of the 2 years.
If I recall, what would have been presented in the first instance was the 2 years or more. But we never yet saw what would have been constituted as the schedule. It is upon receiving the schedule, and we started to review the contents of the schedule, then we raised some concerns in terms of what would have been defined under a particular legislation that would form part of the schedule to say, should this be treated as a disqualifying offense? And so we started to raise concern about that list now under a rubric of a particular legislation. And so that may have been the direction that we had taken it. So you have the question, sorry, Solicitor SG.
No, I apologize. You were not finished, so I'll wait until you're finished, Senator Gale.
Okay.
Sorry about that.
So, and that's a good way of, I've said that to employers when you want to distort my thought. You say, no. So it was a distinction between examining what would be constituted as that list of offenses under each legislation and whether or not under that list all of them were confined to 2 years or more, or whether or not they are so egregious in nature to expose the risk of disqualifying a teacher because they are associated under a list of legislations that now pose itself under disqualifying offenses.
Sent to prison for 2 years or more.
Well, we don't know if all of them, because they are under the list of offenses under a particular legislation. What we had questioned is whether or not this could imprison you for 2 years or more. In all cases. Again, Member Braham, I don't know if being a nuisance, public nuisance would public nuisance or challenge to fight under the offenses at common law would punish you for 2 years or more. But it is under the list that would have formed itself as part of a disqualifying offense. And I'm only using that as an example. Because if we're going to use the list would be taken into consideration in its entirety.
So the question I'm asking, and I probably asked already, is if you remove the list and simply say offenses that you could be imprisoned, and I'm not trying to frame it or anything, for 2 years or more, whatever those offenses are, is that too wide? Is that what you're saying? You still have to go and still put out a list?
No, that would have been...
If I may though,
go ahead,
please.
no.
Thank you. Well, I'm trying to adjust the volume. Okay. The 2 years, 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 the the way how it is in the bill, there would be no need for a schedule or a list. But I think the issue was that members wanted to have an idea of the types of offenses that would fall under the rubric of 2 years or more. But to answer your question, Senator Brown, and as you know, there would be no need for a schedule. There would be no schedule. There would be no list in the law, because all it would say is once you were received a penalty of a term of imprisonment of 2 years or more. And that's all that's needed. But perhaps the disquiet is the types of offenses that could be caught under that.
It doesn't seem so. You see, if we were to embark upon listing every offense conceivable, some of them are going to be left out. So if we have a situation where we say a type of offense that you could be in prison for 2 years or more is in the nature, I suppose that is one way. I don't want to be too definitive because the criminal law is not an area that I have much knowledge about. So I have to be relying on others.
Right.
But just generally speaking, it seems to me that 2 years is a relatively senior offense. Or should I say serious offense? I don't know.
Well, I'm agreeing with you, member, that if you can be charged for 2 years or more, then that, we should just refer to it that way under these different acts. Right? Yes. Yeah?
What is happening, sort of also then, is that the way it is that the judge may give you 6 months for what otherwise would be a very serious offense. But you get 6 months. So if you treat it from the point of view that the actual conviction or as against what you could have been convicted for. So some offenses you could be convicted to up to life, but the judge may choose to give you 6 months. Would that be a disqualifying offense? It would be a disqualifying offense if you use the theoretical possibility as against what actually happens. So I don't remember what was the actual formulation, if you could remind us.
Go ahead, SG. Or who is that?
Thanks, but I think I saw Ms. Spence from Legal
Oh, go
Reform
ahead, Ms.
Department.
Spence.
I don't
Ms.
know
Spence
if she
and then
wanted to
SG.
speak on the issue,
All
and then
right.
I could go after.
All right, thank you, Ms. Spence.
Thank you, SG. I wanted to indicate that the June 8 minutes may give some indication as to how we got to the list of disqualifying offenses. I also would like to point out that there was a concern that based on the definition of a disqualifying offense, clause 27, which indicates that a person is eligible to be registered as a teacher under this act if the council is satisfied that the person is not a disqualified person. When you look at the definition of a disqualified person, it indicates that that person is someone who has committed a disqualifying offense. So there was a concern about teachers not being able to be reinstated or not being able to be registered as teachers because they have committed this disqualifying offense. And then it was important to sort of give an idea as to what would constitute a disqualifying offense based on the definition of the disqualifying offense of 2 years or more that's given under the bill right now. And when you looked at it, I believe that there were some concerns regarding some of the offenses that persons could be convicted for 2 years, whether or not they were of such a character that it warranted not being able to become a teacher or not being able to be reinstated as a teacher.
The policy of the state in terms of seriousness is demonstrated by the fact that you have the legislation, the parliament has considered it, and decided to impose a sentence of at least 2 years or more. And so therefore, I would take that to mean that the public policy is that this offense is a serious offense. I then shouldn't be able to say, yes, you could go to prison for 5 years, but society mores have changed, and so therefore 5 years, the offense is neither here nor there. So I think we should be guided by the public policy as demonstrated by the legislation. I don't know.
Go ahead, SG.
If I may, Chair.
Go ahead.
Thanks. Just to address an earlier point about a concern about the formulation of the definition of disqualifying offense and what it would, how you would interpret it. So the language can be so formulated to give full effect to the policy. If the policy is that the disqualifying offense is an offense for which the penalty is a term of imprisonment for 2 years, that's one thing. If, however, you want to address a situation where it doesn't matter what the penalty is, but what the person was actually, the penalty imposed on the particular offender, then you can recraft it. So instead of speaking about the penalty for the offense, you can speak about the term of imprisonment, for instance, that the person which was imposed. So for instance, I go to section 41 of the Constitution of Jamaica, which talks about the tenure of office of senators and members of the House of Representatives. And it speaks about what is a disqualifying feature or factor. And it includes if the person is imprisoned for a term of or exceeding 6 months. And then it goes on to speak about consecutive sentences. So it says where the person is sentenced to 2 or more terms of imprisonment that are required to be served consecutively, account shall be taken only of any of those terms that amounts or exceed 6 months. And it also says no account shall be taken of a sentence of imprisonment imposed as an alternative to or in default of the payment of a fine. And I know I've raised this before. So I'm just reminding the members that the language can be formulated to reflect the policy. So it just depends on what the policy is. Thank you.
Madam Chair, through you, based on what the SG said, which she had said sometime before, we had come up with a definition for disqualifying offense to say disqualifying offense means an offense for which the penalty is a term of imprisonment by whatever name called of 2 years or more, including a sentence of imprisonment, the execution of which is suspended. So it captured the term of imprisonment and also if it was a suspended sentence. So perhaps this formulation could be considered, even if we're gonna tweak it a bit. And perhaps you would want to see it on paper in order to properly consider it.
The sentence is a term of imprisonment. And so many sentences say a term of imprisonment of X years or a fine. Those would be covered if it has a fine as an alternative.
No, if I may, I don't think well, that's the point. I don't think that was intended. I don't think the intention was to cover all offenses that could attract a term of imprisonment of 2 years. I thought the intention was that if a person has been, if a term of imprisonment of 2 years or more has been imposed on an offender, that is what would be the disqualifying offense. Not what could have been imposed, but what actually was imposed. But you see, I'm not clear either. But I really thought, earlier that was the intention.
All right, so could I ask our legal persons to present us at the next meeting with a formulation for this, or it's already?
No, can I just say, Chair, please?
Go ahead, SG.
Yeah, no, I think before the attorneys can give, or even the drafter can give a formulation, because she's giving you one there, but there's another alternative to what she's proposing, which is what I'm saying. I think there are two things you could look at. Whether the offense itself attracts a certain type of penalty, or whether the offender was actually subjected to, or this specific penalty was imposed on an offender. I think we would need guidance on that before anything could be drafted.
Right, but if I go back to what Member Braham was saying, if the offense attracts, Member Braham, 2 years or more sentence, right? That should be the basis.
Well, that's actually in the bill, but we're asking if that really is the intent, or is it that you want to get the persons who were actually sentenced to imprisonment for 2 years?
That is the question.
Right.
It appears that the original policy persons intended the persons who were capable of being sentenced for 2 years, as against those who are actually sentenced for 2 years. But I mean, it appears from what I'm listening that at previous iterations of these discussions, there were members who had some discomfort with that. They had discomfort from, in one, they thought it should be the actual sentence, and they also wanted to know some of the offenses.
Right, so at the time there was not clarity around the offenses, and we've had that since then. So I think we're at the point where we need to decide, the 2 years plus, given that we've seen the offenses, the details of the offenses. All right, could you read the original as is? Yeah, that's in the bill currently. Yeah, 2 years. Yeah.
Disqualifying offense means an offense for which the penalty is a term of imprisonment of 2 years or more.
All right, we will leave it there in terms, and well, we'll come back to it. No, I'm talking about that clause to leave it as is, and we'll ratify it at the next meeting, the next sitting. Right, we'll leave it as it is originally. Or ratification at the next meeting. All right, members. Our next meeting of the Joint Select Committee is scheduled for Thursday, January 25th at 2 p.m. What, you have something? All right, members, the next meeting would be Wednesday, February 7th at 10 a.m. At that meeting, we will be going through the updated version of the draft report. And so this will be in your email boxes prior to the meeting. I'm encouraging all members to read because we're going to go through clause by clause to ensure that we are in agreement with what's in the report because it's going to be laid in Parliament. And so we have to go through clause by clause. So that's what we'll be doing at the next meeting. Additionally, at that meeting, we will ratify the decision with regards to morning. So Wednesday will be the next day. We don't have the afternoon on Wednesday. Open? Members, based on this schedule, Wednesday, February 7th at 10 a.m. is open right now, and so we will take that. And I'm saying watch your emails for the draft report because that's what we'll be focusing on at the next meeting to go through. We will confirm as well this clause about the offending, the disqualifying offenses. All right, but we are transitioning to looking at the draft report, go through that, and if everybody comes having read it, we should be able to go through at a pace. But the technical team will go through before the meeting. Yes, in terms of the reading. All right, members, three things. The next meeting, Wednesday, February 7th at 10 a.m. At that meeting, we will seek confirmation for the wording for the offenses, the disqualifying offenses, and we will go through the draft report clause by clause. All right? And we should feel very happy that we are going to go through the report, the draft report. It suggests, huh? Yes, yes. It says. All right.
Chair, can I just ask a question?
Sure, please go ahead, SG.
Thank you. As it relates to the draft report, are we to look at, there was a version sent this afternoon. Is that the version we're to consider,
No, please,
or are we to
no.
await another?
Right, there'll be an updated version
Okay.
before we
All
come.
right. Thank you for that.
Well, before we come to the next meeting.
Thank you for the clarification. So we will wait on that updated
Right.
version then.
All right.
Okay.
So, thank you so much, members. All right, and I think that brings us to the end of this session. Let's go back to the agenda. Is there any other business? None? There being none, and we've set the date for the next meeting. This meeting is adjourned. Thank you so much.